All right, welcome to the video lecture on Chapter 4. This chapter deals with witnesses, competence, and privileged communications. So under the common law, there were a lot of reasons why witnesses would not be permitted to testify. They would be declared incompetent. Under the federal rules of evidence, though, Rule 601 says that every person is competent unless the rules provide otherwise. And the rules say that only the judge and the jurors who are sitting in the case on trial are declared incompetent to testify in that case. And this makes sense. They're supposed to be impartial. So in general, for someone to testify, we just require that they have knowledge about the facts, they understand that they need to tell the truth, and that they take an oath or an affirmation that they are going to tell the truth. We don't have any mental or moral qualifications to testify in courts. In all the federal courts in every state but Arkansas, all persons are competent to be a witness. And you cannot say someone cannot testify if they're an atheist or if they lack a mental capacity. None of those things impact your ability to actually testify. So although everyone is competent to testify, you do have to have capacity to testify. And capacity is defined as the ability to perceive, the ability to remember, and the ability to narrate the events in an understandable manner. Those are witness capacities. So all witnesses are competent, but a witness might not have capacity. If we think of a witness who maybe observed something but has Alzheimer's, they would lack capacity to testify in court. In under some rules of evidence, there's a fourth element of capacity, which is sincerity. But this can be inferred from all these other characteristics. There are some recurring problems as far as qualifying a person to testify. With children, sometimes they're too young to either understand their obligations or to communicate effectively. A person might not have the mental capacity to understand or communicate. And someone might be under the influence of a substance that impacts their ability to be a witness, such as drugs or alcohol. So we'll kind of handle these bit by bit. All children are eligible to testify. When a child is very young, the capacity is an issue. So what happens is a judge will determine if a child is able to understand what's going on around them, remember the events, relate what happened intelligently to others, and appreciate what it means to tell the truth. Judges will frequently talk to the child in question in their chambers, in camera, and they will come out and say whether or not the child meets the standard. If they do, though, they can testify. The burden of proving this rests on the side who wants to call call the child as a witness. And investigators need to be very careful when they're working with children victims and children witnesses because they don't want to plant an idea in their mind. So the way that you work with a child can be very different than the way you work with other witnesses. Now, persons of questionable mental stability, somebody who is senile, has been declared mentally imbalanced, or drug addicts or alcoholics, can also be a witness because they might still have a lucid moment. For an individual who this would pertain to, they just need to demonstrate they have basic capacity, the ability to perceive and remember and narrate. And then they further have to have that personal knowledge, understand that they have the obligation to tell the truth, and then take the oath or affirmation that they will tell the truth. So as long as they do that, they can testify. Federal Rule 605 declares a judge presiding at trial cannot testify as a witness. And Federal Rule 606 says that a member of a jury cannot testify as a witness. And once a verdict has been reached, neither side can delve into a juror's minds or emotions during the deliberation because this could cloud the verdict. All right, let's shift gears a little bit and talk about privilege. There are certain circumstances that can arise under which a person can either choose to refrain or might be prohibited from testifying about certain information. This occurs when the person who has the information gained that knowledge or information as a result of a confidential relationship. So privileged communication is an exchange of confidential information between persons who are in a privileged relationship. And we want to promote and encourage this type of relationship. You need to have, there are certain times or events that you need to be able to talk about freely, and you should not be penalized for doing so. So if a privilege exists, evidence of communication made within that privilege is barred from a legal proceeding unless the privilege is waived or an exception exists. So forms of privileged relationships are husband and wife. I wish they wouldn't put parent-child on here because this is not a privileged relationship, even though there is a movement that it should be, that you should be able to talk to your child about anything, even a crime or a serious events with serious repercussions without being forced to testify against your own child or your own parent. Attorney-client and physician-patient, psychotherapist-patient, clergy, communicant, law enforcement officer, informant, accountant and client, and news reporter and news source. So all of these can be privileged. Not every single one of them is going to be privileged every single time, though. And so this chapter is going to spend a lot of time delving into that. The general principles are, if privilege is held by one or more of the persons involved in the relationship, everyone holds the privilege. So that means anyone can assert the privilege. And someone who holds the privilege can waive it by either disclosing a significant part of the communication or consenting to the disclosure of the communication. If you waive your privilege, it is waived for every other purpose. And if two or more persons hold a privilege, such as like if a group of people consulted with an attorney, waiver by one does not affect the right to claim the privilege by the other persons. Just because a privileged relationship exists does not bar the person from testifying, but it just means that part of what they can testify about is restricted. So first things first, husband and wife. This is the rule that one spouse is disqualified from testifying against another. This has a long history. Spousal incapacity privilege says that when a spouse is called to testify, they can have the privilege to refuse. This spouse is held by the spouse who's a witness. So the spouse who is a party to the lawsuit, or in our case, the criminal defendant, does not hold this privilege. A spouse who would be the witness holds it. And then there's the marital communications privilege, which is that communications between spouses during the marriage is privileged because this is an important part for there to be stable marriages. That privilege exists even after the marriage is dissolved by divorce, annulment, or death, as long as the communication was intended to be confidential, it was between the spouses, it was not a crime of one spouse upon the other spouse, and it was not overheard by a third person. So, and this does not cover information. This privilege extends beyond the actual physical boundaries of a marriage. It can include facts learned before the marriage as well as facts learned after the marriage. And then it's just really important to highlight the crime or fraud exception. There's no privilege if you commit a crime or fraud upon your spouse. Now shifting to parent-child, this would protect parents or children from testifying against their family member, and it would permit confidential communications. Again, though, this is not the law in a lot of places. So attorney-client privilege, this is formed when someone who's authorized to practice law enters a relationship with someone who went to an attorney seeking services or advice. So the attorney has to be licensed, and we need them to communicate. If the communication happens in the presence of a third person, it is no longer confidential. And any information that's furnished to the attorney by the client as a result of their role as the attorney is considered to be privileged. So this is going to include written, oral language, hand gestures, or acts on the part of the client. If during the consultation with an attorney, a client should display a gun or money or scars or marks, like a tattoo or something, these two would fall within the privilege, as long as they have connection to the case that advice is being sought about. There is a crime exception to the attorney-client privilege. So when a person consults with an attorney about the commission of a future crime, or for the purpose of concealing the defendant after a crime has been committed, then the attorney can break privilege and go forward. In general, the future crime, some states have limits. It needs to be serious bodily injury or death or substantial financial harm. Other states, it's a little more broad. Physicians and patients have privileges in most states these days. This is just to protect the patient's privacy and for there to be kind of full communication between the doctor and the patient to effectively treat. But this does not exist in the federal courts. Psychotherapist patient privilege is when you are consulting with a psychotherapist for diagnosis or treatment of a mental or emotional condition. A psychotherapist does not have to be necessarily a psychiatrist. Some states recognize other persons. And so the information shared for treatment is privileged. There is a dangerous persons exception for this privilege, where if the person is a threat to themselves or another person, then they can disclose. Clergy communicant privilege is recognized in all the states, and so if you go to a member of the clergy for spiritual advice, then that information is protected. This idea being that if you want to seek forgiveness, or talk about the spiritual aspects of some past bad thing you've done, we don't want to stop you from doing that. There are law enforcement officers can protect the nature of their informants, and that's kind of an offshoot of governmental privilege to protect certain information. In 29 states, but not the federal government, there is accountant-client privilege. And news reporters can also have some privilege about disclosing their sources. This was not recognized at common law, but it has been recognized at the federal courts and a lot of state courts. So this would cover the information that the reporter discovers, including sources and background information. So we covered a lot here. If you have any questions or